Hi everyone, I'm immigration lawyer John Kasravi. Thank you for joining us again today, May 5th, Wednesday, 5 p.m. Pacific time. Here to take your questions, live general education questions about U.S. immigration and talk about what's going on, all the changes, everything that pops up. Just shoot them right here on YouTube, on Facebook, on LinkedIn, on TikTok, all these different platforms. We're there for you. I just want to let you know that we are still doing our free consultation raffle, which means that if you're watching this, especially on YouTube, you like, comment, and you get chosen every 10 minutes. We'll choose one person to do a free 15-minute consultation to talk about your case and see what's going on, see if we can be of any help. You just got to watch, and when your name is called, I'll give you instructions. Take a screenshot to prove that the comment that you left was your comment, and then email it to me at info@jqqlaw.com, and there I'll check it out and I'll send you an email to schedule a consultation. There'll be a link for you to do a video consultation by Zoom, or if you need it, a phone call if you can't set up the camera. But I think it's gonna be fun doing that. So hey, with that, let's get it started. You know, this week has been a traditional wild week. You know, India, where it has had a lot of backups, it's gotten even worse because of the shutdowns, getting exceptions to the travel ban, the COVID travel bans, the NIE, the national, national interest exemptions, or whatever they're called. Those have gotten more stringent and more difficult to get. It's been a real nightmare, but hey, we gotta do what we gotta do. So Bud asked, what's the news on updates on K1 Fiance visas? Well, one of them was that essentially there are gonna be exceptions for the K1, but hey, who knows when that's gonna happen, but they're gonna give them priority to get those in and start doing interviews, but we have no idea when it actually practically is gonna happen because each embassy makes those decisions on its own. We have a good question here. What is the I-94? This is something that's really important that pops up and a lot of people aren't familiar with. When you start an immigration case and say, hey, I want to, for example, do it in the United States. So I'm going to apply for adjustment of status, a green card in the United States, but you end up having to leave the United States. Well, you got to have the file transferred overseas. And so for the government to do that, you have to submit Form I-824 to tell them that once this I-130 is approved, send the case out to the embassy for consular processing. Unfortunately, this I-94 costs money and it takes an unknown amount of time. If you look at processing times on USCIS, sometimes it says it takes 10 years to do this. It's kind of ridiculous. It doesn't take 10 years, but sometimes it takes a year or two. So, you really have to plan ahead of time about what you're going to do about your case because you want to avoid at all costs having to do a Form I-824, not only because of the cost, the money, the filing fee for it, but also because, more importantly, the massive delays with using such a form. So I really recommend avoiding that to the extent that you can. Karundi Bass, hi sir, would you be able to apply for a driver's license in California with just the worker permit? Well, if you have a valid work permit, that could be used as part of the process for getting a driver's license in California. It depends on who you're dealing with at the Department of Motor Vehicles, the DMV. That office, every time you go there, do something differently. But the work permit itself, if it's properly in the system where the DMV can connect with USCIS, then it's possible, but it depends on your status, what kind of work permit it is, what your background is. There's a lot of different things that go into this. So, I can't say for sure it's gonna happen. That's why I say you gotta check it out. First of all, we'll talk with the lawyer about your case to see what the situation is. But secondly, it's up to the DMV officers and how strict they wanna be. Levy asks, I'm close to being a citizen. Well, great. I filed my I-130 for my wife. Once I'm a citizen, what form or what process is it to update my I-130 for a green card petitioner to a U.S. citizen petitioner? Well, the process is that just sending a letter with evidence that you're a citizen, your naturalization certificate, to USCIS with a copy of your receipt so that it could connect the I-130 that was filed with an LPR, green card holder, and connect that you're a citizen. Now, it shouldn't really make a difference in your case from my experience. One is I've done this before where even though we mailed it to them, we had to call them 3 or 4 times until they understood it. But even with that, it didn't make a difference in our timelines, but who knows, it may be different this time around. Might as well do it. Noor asks, hello, I'm waiting for my I-129. That's a work, I-129 is a work visa. A work visa, non-immigrant visa. Non-pro-tunc, which means they're trying to fix it up, an error that happened. I leave the U.S. now without waiting for a decision. What happens to my petition? Will it get rejected automatically? Yeah, if you have a change of status case pending and you leave while it's pending, it's going to get rejected automatically for abandonment. If it's an extension of status, they play it differently each time, but probably it'll keep going. But it's not pro-tunc, so you're already asking for a lot. We'll see what actually happens with that case. Alicia asks, I filed my IAOS, my adjustment of status case, in March 21st, 2001. Application as rejected due to wrong address, lawyer mistake. refiled April 21st, you say 2001, and maybe it's a typo here, maybe 2021 you mean, but my I-94 expired April 30th. Do I need to file a waiver due to expired I-94? Well, a waiver won't do anything in that kind of case. Ali, it depends on what your adjustment of status is based on. If it's based on being married to a U.S. citizen, then no. But if it's based on being married to a green card holder and your I-94 expired, it could be a problem. It's not a waiver you'd file. Maybe it gets really complex. So if you're married to a U.S. citizen, it doesn't matter. If you're doing employment-based EB-1, 2, or 3, it doesn't matter as well. But if it's other categories, you got to consult with the attorney in private to see how to deal with that if possible. Hopefully your case is okay. You may have to leave and do consular processing. But it's a deep analysis that has to happen. Noor Ahmed follows up, thank you. Actually, it was an extension case, not change of status, so USCIS will still process the petition if I leave the U.S. without waiting for a decision. Please respond. So Noor, there's this memo that came out in 2001-ish, I think, or 1998 or something like that, said if you have an extension of status case pending and you leave, that leaving will not lead to an abandonment of your case. Not every attorney agrees with this, but I think it's possible. But then again, you have a non-proton case. It's a little more deeper issues than that, and I need to know your whole case facts. So I can't say your case will happen like this because I don't know all the details and nuances of your case. Talk with your attorney about that. In general, it is possible if you have an extension of status case pending for 9129 that it'll still be pending if you leave and come back. But there's a lot going on there that we'd have to analyze. So I can't say for sure that this would apply to your case. Alex asks, can you do the FD 258 fingerprint cards from I-75 live scan? No. For Form I-75 on removal conditions, you have to do a biometrics appointment where you go to an ASC center for that. If they don't waive it for you, do it there. You can't go on your own and do the fingerprints and send it in. That's not how it works, Alex. So unfortunately, you would not be able to do that. Sugar Love asks, hi, will DNA be accepted to prove that my sister and I are siblings? Thanks, have a good weekend. So, you know, maybe not. It's up to the officer. You really want them to ask for DNA. You could submit it beforehand. But the way to prove your siblings is using your birth certificates and showing that you have a parent in common, all that kind of stuff. Just do it the proper way. That should be fine. If you don't have that documentation, it gets more complicated. DNA may be required, but that's the last resort. When Trump came, he added this requirement that if you're doing a spouse of or child of a person who has some sort of visa in the United States, you have to do a fingerprinting appointment. This was not the case before. So if you're doing H4, L2, O, whatever these other different categories for spouse and dependents, now you have to do fingerprinting. And it's been really bad because these spouses are taking over a year to get the biometrics and the work authorization going. So it's been a major headache for these categories. And there's been lawsuits, and great colleagues of ours at Wasden Banis, it's a great immigration litigation that keeps suing the government. They essentially won out. Where the government said we're not going to require biometrics fingerprinting appointments for the E category spouses, L2, H4, and I think just those three. Unfortunately, it wasn't wider than that. But it's great news because these people are going through a lot of hell to be able to just get things going. So I'm glad they're able to help them out and go through that. About a topic I've been wanting to talk about in a while, because a lot of people contact me and say, I want to come to the United States, I want to immigrate, how could I immigrate, how could I live the better life in the United States? And I always back up and say, listen, although it's my job, it's my business to make money off helping people come here, I don't always think it's the best decision to do that. So the primary 3 ways I say people, or 3 or 4, to come here is this, because it's a really difficult thing to immigrate to the United States. Just immigrate in general, even move your house from one state to another is a headache, let alone to another country which may have a different language, a different culture, a different attitude. These are the facts I tell people. I say, listen, is your life in danger for where you are? Are you trying to escape for your life and do asylum, for example? And then yeah, you should probably get out and come to the United States because it's your safety. Secondly, are you an entrepreneur? Are there much better opportunities that you're going to take advantage of come to the United States than come? And this is not just for anybody that you think you're just going to get a better job, because unfortunately there's this perception for people that are coming here. They think that once they come to the United States, they'll be able to just get easy money and everything's going to be easy. But the reality is, in the United States, it's a treadmill. I hope you all know what a treadmill is. It's this thing you run on, you stay in place, but you keep running. And US is a treadmill that keeps getting faster and faster, but you still stay in your place. So no matter how much money you will make, it's going to get more taxes, more expensive lifestyle, more costs, and more headache. So it's not like a lot of foreign countries where, although the standard of living may be lower, it's a more peaceful, relaxed way of life, regardless of what the political and social situation is. It's very difficult living in America. It's very, very, go, and you can't sleep, and you kind of have to keep running. So you got to prepare for that. You're going to really do something that's different. Third is if you have your children and you want them to live a better life, which is great, because If you're above 30, honestly, if you're above 25, immigrating is very difficult. And you got to be a very strong person to be able to adjust to living in a new country at that age or older. At 25 is young, but it's still hard. I've seen it, and it's just the experiences I had. And then finally, if you're in love and you want to come, well, you got to do it. But don't take this situation lightly. It's a lot of work to be able to adjust to the American system, culture, lifestyle, cost, and everything like that. And many times people regret it and want to go back. It's not that easy, but the opportunities are there for people experiencing the need where they're running away because they need to save their lives, or they have that entrepreneurial or hard work instinct where America's system really allows you to grow. It's going away slowly but surely, but for now it's still the best in the world. My son filed for me, so I will be okay even if my I-94 is expired. Yes, Ali, so if you're a U.S. citizen, you're considered an immediate relative. I'm sorry, not you're a U.S. citizen. If your son's a U.S. citizen, you're considered an immediate relative. Immediate relatives are parents of U.S. citizens, spouses of U.S. citizens, and minor children of U.S. citizens. So if you're one of these categories and you enter the United States lawfully, even if you overstayed, and even if you worked without permission, as long as you didn't, claim to be a U.S. citizen and get a job or something like that, you can adjust status. There's an exception for this under the Immigration and Nationality Act, Section 245 C2, I believe, where it says, if you're immediate relative category, then these overstays are okay. So I wouldn't be worried about that. It's not good that the lawyer said the thing in the wrong place, but hey, it happens. Luckily, your case is not going to be affected. It's just going to delay things by, I don't know, a month or so with it. That's about it. So it is what it is. Love asks, I-485 pending as a green card. I couldn't pay taxes jointly with my wife because I don't have a social security number, so she filed as single without me. So when I get my social, can I amend jointly with her after deadline? I'm worried. Yes, you can amend it, but you should just talk to an accountant. You could file jointly with your spouse. There's ways to do this. Most accountants probably don't know it from my experience, but you could have filed jointly with your wife and taken advantage of lower tax brackets as well and pay a little bit less in taxes. But yeah, you can always amend later, but just compensate, and it's better to amend and submit it, because later on for your I-751 it's good to have joint tax returns, but there's other ways to show your relationship. So with that, everybody, we're done for today. Thank you all for joining. We'll be back next Wednesday, 5 p.m. Pacific time, to take your general questions about U.S. immigration. Hopefully I helped out a couple people get a better idea what's going on, and our 3 raffle winners are going to have their free consultations the next probably next week, because this week's already stuffed full of consultation times, but we'll see. We'll be connecting soon. Thank you all. God bless. Be safe, and wish you all the best till next week. Bye-bye. I hope you enjoyed this educational video. We have a second channel with much more information as well at JQK Immigration Clips. Please check that out. Also, you'll find our social media site has a lot more videos, images, and information about the U.S. immigration process. Please check those out on the various social media websites.